All right, good morning, everybody. First of all, sincere apologies for delay little before we start our program. But I think we'll get ahead. I think we have enough people here from the general public to express some views. We follow some form of structure. We're basically waiting for the provincial lands advisors to arrive and give some remarks. But before we do that, I notice also in the presence in this room the Honorable Governor for Eastern Britain, Honorable Michael Marum. We welcome him, ma'am. And I believe it is only appropriate that whilst this may be a parliamentary committee hearing, we are presiding here in the province. So it's only appropriate protocol that you may acknowledge, ma'am. Now I think I'll ask the good governor if he can make a few remarks before this is a public hearing, so we can make him some remarks per step before we can start proper process belong work block committee. Honorable Governor, ini paiting ana. Yeah.
I'm not dressed up, so
That's okay.
All right, thank you. Good morning, Logada. Past time through me talk sorry through. Me RM Lilik story as a modis colleague MPs from long national government come down. So again, the notice was given to our provincial administration, the staff na. Ogota line long but that's fortunately you miss all kind time na walk about all month. So today is also Friday. Now maybe you'll get some long narblobok, but me talk thank you lo. Papa Fort City Blumibla, Honorable Herman Tabaning Junior, where he's part of the committee as well. Lo come down Luyana, look at him all time only until Naim election meeting. Me look Savelo Chemenet, one time committee member Blungen, Ricky Morris. Honorable member belong Alatau. Me talk big blamas. Lo come up bla loya. Loya lo place him. You lo come down. We make sure we welcome you properly. We make sure you feel at home and make sure you talk to the right people here na. Loya so especially with the land issues we look at the province. Thank you long. Lovan and bla. I was in my office at home now behind me. I knew that I might come around, so I prepared a short speech station. Na me by and then after this I'll excuse myself. Na ba me go too long Rabal. Yeah, thank you, Honorable Chairman and members of the Permanent Parliamentary Committee on Land Matters, distinguished guests, officials and Department of Lands and Physical Planning, provincial and district administrators, community leaders, and ladies and gentlemen. On behalf of the people of and government of Eastern Britain province, I extend a warm welcome to you all. Thank you. Your presence here today is timely and deeply appreciated, as land matters remain a crucial and sensitive issue for us, for our communities, not only here in Eastern Britain but across the nation. We thank you for making time to be on the ground, to engage directly with our people, and to listen to their views, concerns, and aspirations regarding land ownership, use, and administration. Eastern Britain, like many other provinces, faces growing pressures on land due to urbanization, economic development, and population growth. At the same time, our people value their customary land as a foundation of identity, security, and heritage. Balancing these interests calls for inclusive and thoughtful dialogue, and I'm pleased that this committee is taking that approach. We also acknowledge the presence of officials from the Department of Lands, Physical Planning. Their contribution with our provincial administration, local stakeholders is crucial to ensure that land reforms and policies are practical, fair, and sustainable. As a province, we are committed to ensuring that land development is done responsibly, transparently, and it is a way that protects the rights of our customary landowners while enabling opportunities for investment and progress. I urge our local communities to make full use of this opportunity to engage with this committee. Your voices matters, and decisions made is at the national level must reflect your realities and experiences. Once again, welcome to East New. May your meeting be fruitful and your stay in the province both productive and enjoyable. Boina tuna. Thank you.
Honorable Governor, thank you kindly for your presence this morning. And I welcome you and to set the tone and set the scene for this very important engagement with the community. When this is a process where we bring Parliament to the people, as an extension of Parliament, you are given the opportunity to engage, and everything that you will be expressed here is going to be recorded and utilized in the discourse of the process of the committee. Honorable Governor, we thank you, and we take our cue to excuse you. All right, I think we will take our cue to open our, officially continue our program at this juncture, not that it's been open, but along with my colleague MPs, Honorable Hermanto Binding Jr., who's a member of the Kokopo, and a member of the committee, which is the Special Parliamentary Committee into the Customary Land Tenure Reforms and Land Law Development, appointed by the 11th Parliament to engage into these very important and pressing questions. Distinguished representatives of government institutions in East New Britain, and if there's any from New Guinea, from the rest of the New Guinea Islands here, this engagement or this conference or this session is intended for the New Guinea Islands and its relevant stakeholders. Customary leaders, civil society, members of the public. As we all know, Papua New Guinea stands at an extremely defining moment in its development journey. One time, approximately 95 down to about close to 80%. These figures are yet to be verified, but by the general practice in the last 50 years, it is safe to say that the 97% published by textbooks and publications should now have dramatically changed or reduced. Of our land is under customary ownership. So any conversation about economic growth, sustainable development, social equity, or national identity is at its core a conversation about land. So land is not simply a commodity in this country. It is a source of belonging and cultural identity and continuity. It ties us to our cultural practices, it ties us to the continuation of our indigenous identity and our people. If not guarded, if not managed, if not protected and promoted, as a people we stand a great deal of risk to be classified as an very extinguished species in time, endangered species. So, and yet our existing land governance framework remains fragmented. Was maybe structured so that we do become endangered, under-resourced, and too often unresponsive to the needs of our citizens and communities. So this hearing is convened to confront that reality head-on, without excuses. Today we begin a series of inquiries that we have commenced the last 2 days to better understand the challenges and opportunities of developing a customary land tenure law that will provide a coherent legal framework for the recognition and protection of customary land rights. The proposed law will seek to ensure free, prior, and informed consent, promote equitable and inclusive development, and guide the sustainable use of our natural resources, and at the same time, without losing our own identity, without losing our indigenous clan structures and our ownership rights and privileges. We will hear from a wide range of stakeholders, as we have heard initially from the Department of Lands and Physical Planning. We have heard from the National Research Institute. We have heard from the Institute of National Affairs. We have also heard from the Constitutional Law Reform Commission. We have heard from court users or dispute resolution users, mechanism users, being litigants or individuals, and a cross-section of the community. And today it is your opportunity in the New Guinea Islands to engage and express your views and assist the committee of the Parliament, assist your Parliament to come up with, to be well informed in constructing a solution as we progress as a nation. So essentially the committee's mandate, amongst other things, is to conduct a thorough review of the current land tenure system in Papua New Guinea, including customary state and freehold land arrangements. So therefore, identifying institutional gaps and overlapping mandates, analyze the legal institutional frameworks governing land tenure to identify strengths, weakness, gaps, and inconsistencies, engage with the wider community and yourselves to gauge these understandings and these facts or apprehensions or issues, to ensure that governance frameworks such as ILGs are reviewed for accountability and inclusivity. Customary landowners are not left behind as the country advances its development aspirations. As ILGs, as I pointed out in my initial opening, but for your purposes, I think it's important to understand that attempts to integrate in the past customary land into economic development have involved various approaches over time. A significant colonial era policy, which was known as the transformation policy, adopted by the Australian administration in the 1960s, actually aimed to replace traditional forms of land holding with individual registered titles or freehold titles, and to substitute customary law with English real property law. The objective was to create a single centrally homogeneous regulated system with secured individual registered titles after the Australian pattern or the common law pattern. This policy aimed to address claims that the traditional system hindered land acquisition and utilization by enterprising farmers and was incompatible with a cash economy. However, these measures did not succeed in liberating large areas of customary land from custom. Following the lack of success of the transformation policy, legal emphasis shifted post-independence towards group ownership. This was influenced by the national constitution's goals of development through Papua New Guinea's forms of organizations and recommendations from the Commission of Inquiry into Land Matters. The ILG Group 1974 Act was enacted to formally recognize traditional groups and intended to modernize the land tenure system to improve opportunities for participation in economic activities. With the LGIA aim to help incorporated groups develop their land and underscored the significance of questions about customary land tenure. It did not provide answers regarding the demarcation of customary land boundaries or the registration of customary land titles. So even that legislation in itself leaves a lot wanting. It defeats the intent and purposes of even subsequent legislations like the Land Registration Act and so on. And in fact, it defeats fifth goal of our national goals and directive principles to be inclusive and to preserve the Papua New Guinea way. So we have been caught in this conundrum. This heavy work will continue yet, and a lot of fragmentation will continue. And this is why we have many disputes unresolved through the dispute resolution mechanisms in the courts and through mediation. This process intends to provide a cure, intends to provide a solution to the Parliament, not only by a report, but at the end, this committee intends, for all intent and purposes, to provide a bill to the Parliament to map the way forward for this country into the next 50 to 100 years, if not all time. So let me be clear. We're particularly interested in how we can move from a legacy of failed reforms. I stress again, this committee's focus and your engagement would like to be drawn to identify and work with you so we find a way forward to move from a legacy of failed reforms and legal complexity to a future of clarity, equity, security, and enforceability. We want to understand how existing institutions can work more effectively or can be more improved, how our laws can be harmonized, how our communities can be engaging and empowered, and how land-based development can benefit all. So let me be clear again, this process is not about replacing custom with foreign concepts of ownership. It is about respecting, strengthening our customary systems and formalizing our customary systems and making them work in a rapidly changing global economy to make them compatible and inclusive in the Western economy. As we proceed, I urge all participants to share insights openly and constructively. This is not a court where you might say something wrong or incriminate yourself. This is a fact-finding mission, and I wish that everybody engages freely and openly. We seek not only to gather evidence, but to build a foundation for consensus, clarity, and commitment. This hearing is not an end in itself. It is a step toward a robust legislative and institutional framework that places landowners and communities at the heart of development. So, like I said earlier and before, let's engage carefully and from this side of the table and your side of the table to question thoughtfully, deliberate with integrity and diligence. Madam Disla, thank you once again, and I welcome you all to the New Guinea Islands chapter of the Parliament's committee hearing into customary land tenure reforms and review. With this, whilst we are still waiting for the Provincial Lands Advisor, I think we will do great justice. And I'll take this opportunity, and I recognize very prominent people in this room. I'll call upon a prominent lawyer and senior citizen of our country, Mr. Norbert Kubak, as a court user and litigant, and to share perhaps his insights and have commentary, and we can engage at this juncture, if that is, Mr. Kubak, if that is your wish and will to contribute this morning. So if so, if I can invite you to the front and we also have with us in the room the Deputy Governor, and if I could also thank you, sir. Thank you, sir. Manifest. We also have with the Deputy Governor also in attendance, so thank you, sir. It's a bit, we keep things fluid, but if I can give initially 10 minutes to express some views, but perhaps if I can start with the Deputy Governor. For the record, if you don't mind me asking, if you would be so kind to mention your name and whether you would be speaking on behalf of the provincial government or not, and or your views are for an ILG you're part of, or a clan, and we can take our cue from the point within 10 minutes, and then we can keep rolling.
Okay, thank you very much, Chairman of Special Parliamentary Committee, Honorable Keith Iduhu, your deputy, Nikki Morris, the deputy chairman, and committee from you, Honorable Eramanto Binding Jr. I'd like to say thank you for being with us in East New Britain. I welcome you all to East New Britain. What we want to stay on behalf of our people. I'd like to say thank you because many of our issues, especially customary lands, I'll talk on customary lands, especially for my people, the binding people. There are laws that are put by the national government to control our land issues, especially customary lands. What we have noted so far, I'll bring to our attention 3 areas where it's a concern for the binding people of East New Britain. I, as a representative of our people in East New Britain, I'd like to bring to your attention what we have been experiencing. The first, the national government says, do not sell customary land. That's coming from the national government. But we have customary lands being sold. It's through some documents that have been arranged by the Division of Lands through the government. They usually get the papers to sign. In my view, that is outright illegal land sales. When the government says do not sell customary land, and yet our provincial government, through this document, is selling customary land. That has to be clarified to the people. Secondly, we have concerns regarding incorporated land groups. There are processes that they have to follow. I am disappointed that the advisor is not here. Even some of the officers, they are doing shortcuts. The process is the village people, if they are going to give customary land to somebody, they meet in a village and then come to the LLGs. The LLGs will get whatever the views of the people. They discuss and they approve that, and it comes to the district. From the district, it comes to the provincial administration, and then it goes right up to the higher level, up where the national government is. At the moment, there is shortcuts. They are just coming, going straight, avoiding us in the local level governments. They are going straight to Port Moresby. And that's where we have a lot of land issues. I can vouch for that. It's happening in our areas, and we have land disputes. People are fighting amongst themselves. The third one, which I want to bring up, is the value of land. I have to get this in point. The value of land, when a mining company comes into Papua New Guinea, or even like we have the oil palm industry, when they develop the land, if we want to take back the land, it will cost us millions. It will cost millions. In the initial stage, when we give our land is free. Like in the mining industry, for instance. If you want to argue against them, they will be putting millions. So, what I want to suggest is, or recommend, the value of our customary land, it should have a value. The overseas company that comes in, the developer company, comes in with its machines. The national government puts some values to them and they come in. But for the landowners, their land is just free. We have to look at that and put value on our land. Like the lands that the government currently owns, they have value. But for the lands for the customary landowners, there's no value to it. I'd like to make sure that we take note of this. We have to find a solution forward, because our land is rich. It's our life, our resources. Thank you. That's all I have to comment this morning. Thank you.
Thank you, Deputy Governor. You make some very important points. Can I ask you to just restate what you said earlier about the ILGs and the process of registration? Firstly, your first initial point was about customary land. In fact, you're right. According to law, customary land cannot be sold. And this is not just a government policy direction. It's actually embedded in law. It's not transactable. How this happens is a real puzzle for even ordinary Papua New Guineans, everybody, and even administrators. So this problem is there's a combination of issues, it seems. One, people are not given, the institutions that are supposed to protect are facilitating, like you said. The institutions that are supposed to map the way forward is flouting, if you like, or abusing law. And the other part, of course, is I think even landowners are not made aware enough of the rights and privileges or maybe they ignore it and they engage in this sort of dealings. And question is, how do we stop it? And so this is a real question you raise, and we'll take note of it, and maybe throughout the course, some of our attendees will maybe have some contribution, but we'll flag that for the time being, and during the course of it you wish to express some thoughts again, we'll come back, but that's duly noted. The ILG process, you said, is there's a process prescribed, but the process you are saying is circumvented or abused?
The process has been hijacked. We have many instances where the landowners are given a trip just direct to Port Moresby, and they arrange for incorporated land groups to be established in Port Moresby. But the provincial government in East New Britain has set the process that due to many of the issues we faced, the process is they have to come to the local level government, which is the government on the ground. We know what is happening, and our board members are there. If they have some agreements, they usually get minutes of their meeting, they sign, and then it comes to the LLGs, president and the board members. They approve what's being said, and then it comes up to our district. From our district, it comes up to the provincial government. So we avoid any unnecessary disputes. But when they shortcut and they just go up, the people in head office, the lands officers, should tell them, you go back right down to your LLGs and then start the process. Because if they don't do that, that's where the problem lies. There's plenty of court cases, disputes. Thank you.
Thank you, Chairman. Through you, again, thank the Deputy Governor, who is also waiting again for the process. But, sharing a very important issue, just like what people of Port Moresby, through our first meeting, did raise regarding ILG and the lands. The committee did invite the lands, but before I continue, let me, on behalf of my people of Kokopo District, welcome the team. And this is something that, yes, this committee is a special committee that appointed by the Parliament, purposely for the customary land and land reform in the country. So basically, we are traveling around to get the views of the people regarding our customary land and ILGs. ILG, and that the very important point that I did raise in Port Moresby. Thank you, Chairman, through you. I did ask the person, secretary, that looking after the ILG registration. And of course, with the question through the chairman, that how many registered ILGs, and then coming out from somewhere, he said 1,000 plus ILGs. But the issue that we raised, according to POMIO, there was a presenter which present through the Environment and Conservation did said something about POMIO. At East New Britain, this is what we face. As a deputy governor of the province, well, the lands department, the lands division are not here, and this is something that it's not good in East New Britain. And I'm talking on behalf of the silent majority. And if there needs to be sacked, discipline, we have to do it now, Chairman. This is something that is very important. Land is our life here in Papua New Guinea. And if they are not here on time, it is, Chairman, through you, we can make recommendation to the provincial government and they can be removed from EAS and advice. Now to your point, and again, from the chair, I said, we have to apologize for inconvenience of the venue from GI and then up to here, but we will come back again. I have to convince my chairman and the committee members that we'll have to come around again the next time because land is very important for us. And I have to acknowledge one of the senior lawyer here that is going to contribute through land. But again, there is no ILG representative through lands department here in East New Britain. And this is something that we found out through the presentation of the lands secretary and the lands division in Port Moresby. and you are aware of that, my good Deputy Governor. And this is something that, yes, the committee have identified this and we take note. But again, I have to urge the people here, and this is confusing through some of the land group, customary group, and also some stakeholders, that bypassing the system to Port Moresby. Port Moresby is not the place to solve the problem. And today we can see, problem that we are facing here in East New Britain, not only in East New Britain, but throughout the country. Land grabbing, because of the other ILGs, maybe saying that we are claiming the land, and then both parties are complaining and resulting in burning down of the houses. Di sila M1 plus B plus something, mi mas tok pisin so that all man tuloy mas hari. Suppose mi wok lo stop na hari mo de sila paper man inside lo street long kisim ILG, we have to be careful. We must look out. There is a process. You have to go through the process of the provincial government district, and like in the districts, we got land district offices. Now, lawyer am advisable lawyer, but now she's not here. She might be preparing for something to come, but now we are going into lunch hour, and this is that cannot allow here in East New Britain as one of the leading provinces in Papua New Guinea. So, Chairman, through you, me talk that's all for the benefit of the people, that we cannot continue to abuse the time. Time is very important for us. We are here. This is a special committee to identify some of the issues, and we can present the report to Parliament, and maybe, the Land Act 1974 can be amended to 96, so that we can look Kepserim Sampla all need, so that you now can become a title holder for your respective land within the country. Thank you, Chairman.
Honorable Member, good thinking observations. Committee member, I make him. I think also re-emphasizing some very critical points raised by the Honorable Deputy Governor in relation to processes and procedure. At this point, until the law is changed, because the law will change to improve, this is the objective. But until then, these ILG observations from the previous hearing, and I think also hearing the general public, is causing a lot of problems. But at the same time, they are professionals who do this work. Pepaman sanablo market na, arelo marmar na sa kisimol, painimol clan lo make him walk. Ikato lawyer staff or accountant staff or true manoli school where professional code of ethics by guide all. Ulino kena brusim. But you look him even outside all courthouse all man pull up matamol pepa. All you folder na rano samol come up lawyer. This is a real problem in this country. And we give no good name law, industrial law too. And give name no good too long all officers law, court one time or department law lands. So we just need to be wary. The general public too must be careful in engaging with riffraffs and our man about. One time this la, the evaluation point you raise him very, very important too. How on earth does an investor come in and have, assisted by leadership, lo country, lo kiss him access long bush ground resource, and you may work lo negotiate can. You may work lo negotiate can lo how much support I should get, or how much benefit me should kiss him. Law should accommodate, and it starts from the land. You see, if trees, all the way is, sanablo, sanapantablo ground. Gold na kopa, sanapantablo, sil ananidlo ground. Na ground, blow side. You got man Mary stop, papa lo ground, mama lo ground. So these are the concerns, and so therefore consequential valuations or valuable asset is important. Some of these things were possibly overlooked in the natural architecture of the legal framework of ground, of country, at independence, so pre-independence and post-independence. So very important points you raised, and I think we will take note. At this juncture, I thank the Deputy Governor for your contributions. We will, for the time being, move on to Mr. Kubak. I welcome you again to the these hearings, and look forward to engaging with you. If I can open the floor for yourself to make some remarks.
Good morning once again, everyone, and Chairman, Honorable Keith Hidu, committee members, Honorable Eramanto Baining Jr. and Honorable Ricky Morris. I join our governor, in welcoming you and your committee, Chairman, to our beautiful province of East New Britain. I hope your stay will be an enjoyable one during the next few days as you are here. Next, I want to say thank you very much for the opportunity given to me and the Honorable Deputy Governor to say a few remarks up front in respect of the very important issue that you are here to conduct this very important forum on. I want to just, given the time frame for now given to me, 10 minutes, I just want to, as quickly as possible, bullet point a few important aspects that I consider are worthy of mention up front with regard to the whole issue of customary land. Most of what I will say are within my peculiar knowledge as a member of our honorable profession, Chairman, with regard to my practice as a lawyer in various fields, including, of course, land. Let me firstly touch on the aspect of ILGs, Chairman and members. I will repeat the concerns that arise from my involvement in the formation and involvement in litigation of issues that come out from ILGs. What I would like to place on record immediately is that ILGs have proven a very difficult situation, not only in this province, but also with my experience elsewhere. Firstly, basically because, as we all know, we accept for a fact, customary land is communally owned in this country, and East New Britain is no exception to that. In fact, as the good honorable member for Kokopo has mentioned in passing, we have lost lives and we continue to lose property, etc., as a result of disputes that arise regarding customary land in this province. And with regard to ILGs, what I would venture to point out at this point in time is what I consider to be a lack of sufficient consultation with regard to the prerequisites for the formation of ILGs. As I said, land is communally owned, and I think there has been, like the good Deputy Governor has alluded to, there have been, over the recent number of years, there have been shortcuts with regard to full compliance with the legal prerequisites for the formation of ILGs. What I would want to see in this respect is that there must be a lot more emphasis on the consensus of parties involved or groups, clans involved in the formation of proposed ILGs. I know, and we all know, that the certificate that is issued following the application for formation of ILG is for a larger part is basically a certificate of recognition, one of the existence of an ILG, and of course of the recognition of that ILG claiming ownership under customary law, under custom to certain land portions. During the process of the formation of ILGs and the requirement for advertisement of what they normally refer to as a property list, some of those properties or land that is identified in an application for the formation of an ILG, they escape the attention of certain parties, persons, maybe members of the clan concerned or maybe neighboring clans. It has, the advertisement or the publicity required for the publication of a claim of ownership to certain lands, they escape the attention of parties who have interest. And that is a first recipe for dispute down the track with regard to land ownership when certain activities begin to take place on the land concerned. So that's my concern with regard to ILG. What I would like to possibly see is that there should be a serious consideration of a requirement for the registration, the due registration of land that has been identified on an application for the formation of an ILG. So that the issue of registration immediately also gives an added advantage for the proposed ILG in terms of the registration of a land. Once it's registered and its title possibly, the ILG itself is given a power to, for instance, with regard to seeking financial support, financing, they can then, with the title issued in respect of land concern, they can then pledge that as security for finance. So that's what Chairman, that's what I would want to see, that quite apart or in addition to the registration of the recognition of the ownership of customary land, that there should be a process, should be extended for the titling, the registration of land concern, so that it gives that the economic advantage to ILGs.
Just on that thought, Mr. Kubaks, basically you're saying that the ILG assets or the list of land listed on the certificate of recognition of that ILG, you agree that they don't, this does not deem as ownership, right?
No, right, yeah.
Although there is a thinking that when you list that land, it belongs to the concerned ILG. And are you also suggesting, therefore, that this ILG certification or process is misleading, or
it gives? Sorry, Chairman. It gives. I believe a misapprehension. It gives, because, as I understand, it is really a listing, and that is recognized through the issuance of a certificate of recognition. It doesn't give the title that I'm alluding to.
Yes.
That I think quite rightly and fairly should be a process for that, so that it strengthens the right of claim of the ILG or even the individual members that make up the ILG to actual ownership. And I advance further to even suggest that the issuance of a title will then strengthen and give them that added advantage of pledging, if the need to arise, of pledging the title land in the process by way of backup to seeking finance.
So this is obviously a gap in the legal framework you suggest.
So that's why I'm saying that the relevant legislation should be further considered to make allowance for the due titling of land so recognized as belonging to a customary clan that is seeking recognition.
And if hypothetically, if it were the case that the development in this area, in land law, saw land is because we're talking about incorporated land groups. First of all, we have to settle whether members of that ILG are indeed members of a clan. That should be the understanding, correct? Do you also agree, therefore, that in actual practice, not all members of an ILG are actually members of the clan that otherwise would relate to the land that is declared as belonging to the clan? So we're talking about two things. You see, now, right, in the absence of, presently there are incorporated land groups. There is no clan as far as law is concerned in this country. And that is, if you like, a legal fiction. And come up in thinking. But actual fact, everybody is a member of a clan. Correct? Yes. And through the clan, everybody has a belonging or relationship to land. So if we are hearing you correctly, then land that is belonging to the clan should be able to have the capacity to be put up as security. But that process is not documented. So it's lacking the ability, that capacity. Do you agree?
I agree with you. I agree entirely with you, Chairman. There is, and thank you for raising that.
Sorry,
yeah,
Mr. Kubak, sorry to interrupt you at this point. We have our fourth member of the committee who just arrived, Honorable Lawyer Boy Samuel. If I can ask the good member to join us at the front. And you can continue. Thank you, member. You invite him on there. Sorry, coming back to your response to that query.
Honorable member, thank you. Welcome. What I was going to say is, Chairman, when you raised what you just raised, what came to mind with regard to ownership of a clan is the open secret, if you like, now these days, that there is intermarriage, not only within a province, but outside of the province. And as you know, in my good province here, we are matrilineal. All right. We may have people from this province marrying to another matrilineal society, or a patrilineal society. Now, in that case, that presents a situation where the question arises as to, okay, firstly, which custom applies, and secondly, are the products of that kind of union, where does that place the offsprings of the union? Are they members of the clan for purposes of the requirements of a formation of an ILG?
Thank you. I know you have a lot more to contribute on that line. I want to ask you another clarification for purposes of this, and then you can continue.
Thank you.
So therefore, in that situation, if the law that you and I are contributing to envisages or thinks about that particular scenario, which is a real scenario, then law should think about election, if you like, choice. Two things. Firstly, perhaps when the clan is given legal personality instead of ILGs, because ILG is an introduced concept, but what is Papua New Guinea and what is indigenous to this country is clans. So let's say we give legal personality to clans. Then the clans, under law, should have the ability to make her or its own decision. Make its own decision, not as a democratic ILG process, but a customary genealogical bloodline decision-making process where permission is given to that situation. Because passing custom, you may stop one time whole family. Well, you mean a long by you meet bro you meet outside. So we have deaths in the families, we have marriages in the families, where mans have contribute. These practices are going to remain with us for as long as we are Papua New Guineans. But then internal arrangement by uni. Then, but law should give a mechanism of consent. So internally, by you can make him little kai na talk I'm from a patrilineal society, but me marry, so I don't take by line. I'm from a matrilineal society, but I'm a male, so I don't take by line. But me come because me stop law here. Me asking permission for where you can giving me access. Law sit down one time, you mean family law here. In that instance, then the head title would be given to the remain with the clan forever and ever. The use aspect of it, subject to consent and evidence of consent, then is registered in fee simple for say 50 years or 80 years with conditions like normal leases, and that title or lease is bankable. Not only bankable, so you can build, we can build good houses, good homes, makeshift, and we are sitting you sit down good one that law up law God give him you me through tumbonablo you me. That might be a mechanism we could consider. Law should consider. It's a big gap, and you are very really sure that you are raising. I'm thankful for that. That I was hoping someone would raise this question, because it's not only dwelling; it talks about resource benefit sharing too. In some places, there are benefits that are coming out of big projects. And in these big mining and petroleum projects, for instance, or logging projects, the benefits and royalties that come, usually in the forestry sector, sadly, it's elite captured. So this would cure that elite capture, and also in the other sectors as well. But what it happens is, law should accommodate entitlement of some sort, of course with permission, because 50 years on, many families, because of the mixed marriage situations, they reside in either the wife's area or the husband's area, and by custom, when the family is meeting or the clan is meeting, the intermarriage situation, the spouse who is not from they are sitting there at the behest of the kingship. So this should not necessarily equalize, but give some privilege. There are two things, rights and privileges in law. Right, and this is the thinking, this is jurisprudence. When there is a right, you have right. But when you have privilege, you are permitted. So this is what law might consider. Would you agree?
I agree entirely. There are very classic examples in my own family. Me and my brothers, for instance, our children, they are what you can regard as guests on my land. In our society, there are two main tribes here. I'm from one, my father obviously is from another one. We have the Pikalaba and the Marmar. So my sons, I'll give an example of my brother. My brother, who has many children, has bought off a small portion of land from our clan to settle his children. At the same time, his children, they have their maternal uncle somewhere, and they will inherit whatever is left. In terms of land, they inherit from their maternal uncle. They don't inherit from me as the father, or my brother as the father. So as long as they are there merely as guests, and if I am inclined to so, and the clan agrees, I will buy off a piece of land and settle my children. Then again, when I'm gone, there is that question as to how much longer after I am gone do they remain on that land, because then disputes do arise. And if it arises as a customary land dispute, I know they will not have the upper hand, because they're basically the land in the first place was simply purchased by their father, given to them to settle, all the while them knowing that they have land elsewhere.
Yes.
So this is a really classic example. So I agree entirely with you, Chairman, when you say that.
Yeah, so in addition to that, what would then happen is, as the resident or user of that particular space that is put through a consent process and a lease agreement, it leases with the clan. And when I say lease, it means free. You pay an annual rental. So your kingship and there's maintenance of that relationship for the life of your tenure usage there. So when the time is up, and if the original lessee, let's say in your case yourself, passes on to then the mechanism in law remains to provide that security for renewed consent. So you go back to the clan again, start the process again, and if you maintain all in order, continue. But you can only hope in good faith that the law will accommodate our future of our children and their children's children. And for longevity, the net effect of that is this: because land is going to be managed this way, there's more peace, more harmony, and lesser social problems. Because right now there are a lot of problems are caused by land disputes. And I think importantly, Mr. Kubak, you point out the structure of society. I think the same can be said of the New Guinea Islanders and Bougainville and M3.
Yes.
Bigla Pisin and Liglig Pisin. And so you run through your family, tribal lines run through these two main head clans, if you like, or tribes.
Yes.
Clans, and then intermarriages happen and the sub-clans. But this is the subject of anthropology, not a plus space, but the anthropology actually feeds or informs the legal arguments. So this is very important. Thank you. I'll allow you to continue.
I think we've sufficiently touched on that. We'll get back to it some later point. Let me move to Land Dispute Settlement Act.
Thank you.
Firstly, I believe, as you are aware, Chairman, I believe that legal representation should begin at the earliest possible. For now, it is even optional under in the provincial land court. Legal representation is kind of restricted at this point in time. I'd rather see that if there be amendments to this act, it must also address the issue of legal representation.
Very important point. So what our learned lawyer is saying is this: under the Land Dispute Settlement Act, when you take a dispute to the local land court, you don't have a legal representation. You don't got lawyer. Lawyers are not allowed by law to make representation of your interest. That's why a lot of litigants or disputants go to family members or consultants down narrow marmar na sidang close to the table na or man carrying folder around close to the courthouse. This is a very big risk, a very big problem, because when lawyers are excluded or people who understand the reading of the law and application of it are moved out or rejected from the system, then you don't have proper representation and facts are not brought properly. So many times these land disputes, land is given to the wrong clan. Because you mean man, even the magistrate and layman or laymary, and you are trying to figure out, because the magistrates and people making decisions are not necessarily from your area of origin, so they won't know your history. They take what the paper will tell them. But those who are tied by a thing called ethics, rules, example, a lawyer, they will bring out the facts or truth. No, because I'll give him Gaman story. And by statutory committee or IGAT process by making SABL longol too. So they also worry law profession longol. But this is important, very important point to raise, and I think it's a very valid one.
Thank you.
I think the National Lands Commission is now the other part. I wanted to ask you what your views are in that with that mechanism. So since the recent amendments, Land Titles Commission, they've been morphed into what's now called as the National Lands Commission under one. So they would ordinarily deal with this. So the structures are there, but
sorry, Chairman, I may be hearing it for the first time. There's been some amendment.
yeah, there have been some changes. So
And the effect of which is,
the
Chairman?
effect of which is the disputes or issues relating to ownership, customary ownership. Now with the National Lands Commission, which is the morphed in outcome of what used to be under the Land Dispute Settlement Act and others, but if the land that doesn't replace, the body doesn't replace the National Lands Title dispute process, because your issue is still relevant for purposes of local land court, and provincial land court is an option. So that would graduate to finally the National Lands Commission.
Sorry, I was not aware of that amendment on the effect thereof, but what I came thinking of doing was to make a suggestion in the formal, under the existing legislation, the Land Dispute Settlement Act. I was having in mind a suggestion for another level of court specifically for land dispute,
Yes.
above the provincial land court, possibly with a name like National Land Court or something, but a court specifically established for customary land disputes alone, and I think that would be justified given the volume of land that remains in the hands of our citizens. So
That's a very good suggestion.
I was thinking that, and coupled with that, I was going to suggest in the formal ADR track that is now applied in the National Court, that there be a branch of the ADR track specifically again for the mediation of land dispute arising from customary land disputes. So that is what I was going to say.
No, these are not unreasonable recommendations. The committee will take note and take on board. One area, obviously, it's a very delicate area of practice, an area of dispute resolution. So it's also important that the other question was going to be about certificates. Initially, you agreed that ILGs, there's a misconception that ILGs render ownership. Even before that, the problem is created by the mere fact that it's incorporated.
Yes.
Authenticating it and before releasing it, because that a lot of disputes could be averted if that certificate just never came out. So the authenticating process is important under the current arrangements. But assuming if it were replaced by a system of clan formalization, that might be easier, because there's an inherent thing about Papua New Guineans, right? You don't just go and claim membership of another clan. It's hard. But when ILG was a rugby club, anybody can be a member. And because leadership too, it's by democratic election, nomination, they have elections. I don't think clan systems would accommodate that. In some, in most. In others, maybe there's a consensual process, so they take turns to lead the team in families and clan units. So I was going to say, in that process, the filtration process. So before the clan is even given recognition and formalization, there should be a process that authenticates it before it gets to the certificate stage. You think that might be helpful?
It will be helpful, very helpful, Chairman. As you quite rightly say, the issuance of a certificate of recognition somehow gives the impression to the membership, and I guess it's becoming almost like accepted now in the wider community that is like that's a gospel recording of what the certificates shows, that every land that has been published that belongs to this incorporated entity now, this legal entity now, whereas that is far from the truth. You and I know that the land still doesn't belong to that body, that ILG. It belongs to a clan, and so I think the proper body, if you like, would be the clan that should be issued appropriate title, is document in respect of the land portions that have been identified in the application for the incorporation of an ILG.
Thank you, Mr. Kubak. If you don't mind, I'm sure you will have a lot more to contribute. And I ask that you don't go away. We come back with the Deputy Governor. But at this juncture, we made mention of the Lands Administration Office of the Provincial Government. And I think we have here, I've also specifically requested for the banks to make an appearance, something we might have overlooked or did not have a presence in Port Moresby, but the main important threat to understand their views and how they consider how their practices are, or when business was making so. I want to call to the front the Provincial Lands Advisor, if she's here. I saw her earlier. And I should also call to the front BSP, Bank of South Pacific, we have Ms. Kalatriman and Ms. Stephanie Aini. We welcome you this morning. Also the Lands Advisor is here. I will ask that we'll start with the Lands Advisor, if that's okay, we can continue the flow of discourse at this point, and also then come to the bank to give us some insight. So for the record, ma'am, if you don't mind restating your name and your position, and then we
good day, everyone, and good day, panel. My sincere apology to arrive late here. My name is Mrs. Joyce Guan. I'm the Provincial Lands Advisor for East New Britain Provincial Administration. Thank you.
Thank you. Welcome. Can you just, for this record, spell the surname again for me, please?
Guan.
Guan. Ms. Guan, thank you for your attendance this morning. And I noticed also you've handed up a copy of some notes, rather a submission, and we will, for the record, read into the records and pass on to our Secretariat to inform part of the work that the committee is doing at this stage. So I'll allow you to make some remarks if you do not mind, in perhaps 10 or 15 minutes.
Thank you, panel, and honorable members. What's before you is actually a presentation, and the presentation has been passed to the IT people at the back. If you don't mind, I'll run through the presentation
Yes, please.
before our discussion.
Thank
you.
You may proceed.
Thank you. The topic is there. It's land administration and management challenges in Eastern Britain Province. Thank you. The presentation outline is there on the board. Introduction, mission, goals and objectives, summary for Eastern Britain development pathways, legislations, our provincial plans and policies, land sector strategy per the Eastern Britain Strategic Development Plan, our stakeholders, key programs, our roles of its sections, and the identified challenges. Topics that we will be looking at are plantations, Eastern Britain plantation status, the challenges for the plantations, our physical planning and growth centers, establishment and the function of Eastern Britain Provincial Physical Planning Board, the challenges that we have on growth centers, the growth center challenges, and the customary land administration, ILG and VCLR experiences, IRDPs or SABLs in Eastern Britain, benefits of FCAs and SABL subleases, identified challenges by its sections, and conclusions and recommendations. Continue on. On the introduction, our Provincial Division of Lands and Physical Planning was once a unit under the Provincial Administrator's Office and then graduated to a division. This came about after the signing of a Memorandum of Understanding in 1992 and then later on a Memorandum of Agreement in 1997. From that signing of the agreement, it called for decentralized functions that were empowered to the division office in 1997. Division of Lands and Physical Planning came into full function with decentralized powers and functions under the Land Act and its consequential legislations, while most powers are being managed from the mother department. The Lands Division comprises of 5 sections: that's alienated lands and valuation support, surveys, customary lands, physical planning, and the administration section. We have 4 district lands coordinators established in all 4 districts within the province, and the delegated functions have been revoked in 2017. However, our provincial performance is still recognized at the national level. On goals and objective of land sector per the Eastern Britain Strategic Development Plan, our vision is for Eastern Britain Province to be peaceful, safe and secure, where our people will be wise, healthy and educated and prosperous. The goal is to mobilize and manage land to enhance, sustain and further grow the local economy through increased local participation. Our objective is to mobilize and align land through an appropriate social mapping and make land available for local use to support priority development programs, urban development and agriculture development. Having to said that, our Eastern Britain development pathway is listed in the chronological order as from 1994 to 1998 was restoration and resettlement. 1999 to 2003 was rehabilitation and reconstruction. From 2004 to 2008 was integral human development and institutional strengthening. 2009 to 2013, economic development and improved service delivery. 2014 to 2018, economic growth and sustained service delivery. 2019 to 2023 is economic advancement, and likewise to 2024 and beyond, it's still embarking on economic advancement. The list of legislation that govern or we use to administer our core business through land mobilization and land management are all listed herein. There are about 13 of them. Move on. Our provincial plans and policies. We have the Economic Development Plan 2010 to 2030, the ENB Strategic Development Plan 2023 to 2027, Disaster Risk Management Report by Geoscience Australia, Urban and Regional Plan and Growth Center Strategy, the 4 district plans, 18 LLG plans, the Kokopo Tokwa Subject Development Plan, Rapopo Subject Development Plan, which is already outdated. Kokopo Subject Development Plan, likewise, it's already outdated. Northeast Gazelle Infrastructure Development Plan, which was presented, the final draft was presented last year to the national government, and our development control policies. The stakeholders that we work together with, Department of Lands and Physical Planning, which is our mother department, Department of Provincial and Local Government Affairs, Department of Justice and Attorney General, in particular Village Court and Land Mediation Secretariat, Public Curator's Office, and Lands Commission of PNG. That is the recent amalgamation of National Lands Commission and Land Titles Commission. Department of Civil Registry, Police Department, Magistral Services, Government Printing Office, Office of Urbanization, PNG Forest Authority, 4 district administrations within the province, and the 18 LLGs. The number has increased to 23 LLGs now, and they are the SRAs and established units within the provincial administration.
What's a SRA?
Strategic Result Areas.
Okay. Thank you.
Okay, land sector strategy per the East New Britain Strategic Development Plan. We have 5 there. Acquire land for resettlement, mobilize existing government purchase land, support and assist integrated rural development projects to register customary land, improve administration and management mechanisms, letting land to facilitate provision of necessary infrastructures to promote local industries. Functions of land sector by key programs. We have 12 there. First one is on land administration and management. Second one, least developed area intervention. Third, development projects. Fourth, incorporated land group registration. Fifth, voluntary customary land registration. Sixth, ENB Provincial Physical Planning Board. Seventh, growth center developments. 8, resettlements. 9, valuation. 10, lands awareness. 11, plantation redistribution scheme, and 12, ENB Provincial Land Board. What is its section's roles in reference to land sector key programs or East New Britain provincial government projects? There are 4 points there. Point 1, every individual section have a key activity and in any land mobilization assignment, either be routine activity or project. In any land administration or land development and management program or project, all sections will be required to implement their respective roles and responsibilities depending on the type of process executed or the type of development to be carried out. Number 3, it is a must that all officers have to be professionals to implement our roles and responsibilities. Due to insufficient capacity, we also take the opportunity to train our own officers and upgrade them in various areas they are capable to perform in. Such includes in-house training. Fourth, as we are public servants, we must also know the business process in executing assignments within the public service space. On plantations,
Before you
Sorry.
continue the plantations, just very quickly, Ms. Guan. In terms of capacity, in terms of structure, your structure is within the provincial government, or are you directly aligned to lands department separately from the provincial government?
we are within the provincial administration
Okay, and
structure.
reporting wise, how does that work?
Administratively to East New Britain provincial government, technically to lands department.
And do you receive, is there a relationship, explain the relationship again. So the division is within the provincial government, and so
Correct.
your immediate superior would be in terms of your,
The provincial administrator,
and through the provincial administrator, you link up with the National Department of Lands and Physical Planning, correct?
that is correct.
In terms of, manpower in your division, there's a whole list of sectors, areas under in the lands division. Are all these positions filled, or?
Not all the positions are filled. We are waiting for the minor reorg. I think it's the positions through the vetting process through DPM. Once we get approval, they should be advertised for more officers to join us.
In terms of record keeping, do you keep physical records here in the province, or is that something that's left in Port Moresby?
We do have physical records in the province as well. We have our own provincial files apart from what is kept in the department.
And so your division deals with state leases as well as customary land issues.
That is correct.
And in terms of volume or percentage, how do you find state leases work as opposed to the customary land work?
Sorry, come again.
In terms of percentage, is your time dedicated? Is your staff
distribution.
timing dedicated more to state leases or customary land? What's the percentage? 50-50, 60-40, 30-70?
Yeah, it's around 30-70. Given the fact that with customary land, we allow for the customary land owners to come forward themselves.
So which one is 30?
30% is customary land.
Okay. Is there a designated officer separate that deals with, or officers dealing with only customary land matters?
That will be the provincial customary lands officer and the acquisition officer.
Thank you.
Only two. Two.
Thank you. And as opposed to, and the other divisions, what's the staffing like?
Our staff on position, it will be about 25 positions. Staff on strength will be less than 25. So we need to fill up all the positions.
And how many of those 25 positions are relating to ILGs or social mapping or customary land type work?
Two.
Thank you. And why do you think that is the case?
In all provinces, I believe we supposed to replicate what the function and the business process is like from the lands department, the mother department.
From the mother, yes.
But it depends on how we structure and we bid for the positions in each provinces. However, if we are given the support from the lands department on how the provincial structure, in terms of uniformity, the provincial structure should look like for all the provinces throughout the country, yes, we would very much appreciate that.
So is that the model, the current model in Eastern Britain, the same model sort of deployed at the national department in those percentages?
No.
How would you speak to that? What do you think?
We need to beef up the capacity that we have at the provincial level, meaning to say that some of the positions in the province, we kind of amalgamate the functions from the national level at the provincial level.
In your work, do you engage with your neighboring provinces, your counterparts?
Not often.
Do you
not
share
often.
notes, or do you know of their administration? Do you think they would be similar?
They will have the similar problem or experience that we have in the province as well.
You. Now, in terms of ILGs, what do you think? What is your view? If you can go through your notes and you can assist to the relevant part. So.
Maybe we can.
Better still, we continue with.
I'll just continue with the
correct.
presentation. There is a part on
Yes.
ILG and VCLR.
Completely agree with you.
Yes. Okay, thank you. We'll continue with the presentation. Okay. With plantations, there are over 250 described portions of plantations scattered throughout the length and breadth of East New Britain province. The plantations are freehold and state leases. A plantation can have one description or more than one description depending on the initial survey carried out as well as subdivisions done over time. From the total number of plantations, a couple have been designated for the following: 1. Plantation redistribution program, 2. Growth centers and town developments, 3. Resettlement programs, 4. Revenue enhancement program, 5. Private urban developments, and 6. Private subdivisions to cater for the growing population and the demand. The plantation challenges: all plantations be inspected and status update be provided determining the way forward dealing with plantations, provincial development and growing population. 2. A number of plantations have challenges which include: 1. Customary landowner claim over rundown plantations. 2. Not all survey readings are in the present grid not used, hence conversion is required. 3. Duplicating titles over plantation portions, that is freehold titles issued through New Guinea Land Ordinance and issues in recent times using LTC process. Title from New Guinea Land Ordinance is recognized by Registrar of Titles and Department of Lands and Physical Planning Database, as well as Land Titles Commission or Land Tenure Conversion Order is accepted by Registrar of Titles through the administered legislation. Moving on to physical planning and growth centers. East New Britain Physical Planning Board is a functional East New Britain established board. It's governed by the Physical Planning Act and its regulation. We run monthly meetings, including pre-board meetings. It's administered through the division and governed by the Office of the Chief Physical Planner. Our quorum has increased from 3 to 7. Continue. The Physical Planning Office provides the executive advice to the board. The effective board and members are critical when it comes to assessment of development plans. Survey is one component the board members are always critical of, especially stressing on the importance of work done must be under direct supervision of a registered surveyor. The East New Britain Physical Planning Board works in collaboration with our East New Britain Provincial Building Board, which is established under Department of Works. Growth centers. The Urban and Regional Plan outlines a strategy for more urban development in the Kokopo-Tokwa corridor and the Growth Center Hierarchy Strategy, Urban and Regional Plan 2003. The Growth Center Strategy identified growth centers to be developed in order to spread risk of future disasters and to establish service centers closer to the rural majority. The growth center strategy is in line with the government's shifting of focal point of service delivery to districts and local level governments. We have here is the map of the growth center nodes in the province by levels. In one of our urban development plans, which is the Palmalma Urban Development Plan, it identified all the growth centers in the province and it classifies them by levels. So you can see level 1 is Kokopo. Of course, it's now graduated to a city. Level 2 is Call Growth Center, Kerewa Town, and Rabaul Town. And then we move down to level 3 and level 4. So that's been identified in the map there. The next table provides a list of all the growth centers as identified from the map previously. Okay, thank you. Moving on to customary land administration. Oh, it's okay.
Planning. This is all quite impressive. Very, very impressive actually. And this is made possible by what arrangement? Does it have anything to do with the Kokopo City Authority Act that enables this ability?
Well, it's the function of the section within the division. That's the physical planning office, working in collaboration with also the service our stakeholders, who are also service providers and the respective districts.
All right, thank you. Well, it looks very good.
Thank you.
You may continue.
Okay, moving on to customary land administration. Sorry, these are supposed to be challenges from the growth centers. I'll just go through the challenges first. With the growth center challenges, the under-resourced development is at snail phase because we are under-resourced. Funding is a major issue. With growth centers, we need to establish from those growth center nodes, we need to carry out land mobilization business process in order to secure all the land to the state before we can actually plan them out for urban developments. So that's the issue we have with resources. Number 3, surveying is a major component, especially when in the subdivision stage, the cadastral survey is required. Engineering design aspect. When we do surveying, we need our engineers, especially the civil engineers, to work along with us to ensure that the where is designated for urban development properly planned out. And land ownership has been secured to the state prior planning and development of a growth center. I mentioned that earlier on. Thank you. Moving on, ILG and VCLR experiences. I'll run through all the points there. With the focus in customary land administration being the recent paradigm shift, having to encourage customary landowners register their customary land that is still customary in tenure, the customary landowners are willingly complying to the procedures set through the revised Land Group Incorporation Act 2009 and Land Registration Act 2009 to register their clans as incorporated land groups and their customary land through the voluntary customary land registration process or land tenure conversion process. Number 2, after the lift of our provincial moratorium of ILGs in 2019, so far a total of 55 ILG applications were lodged with Lands Division, 31 were assessed and further lodged with Registrar of ILG. under Lands Department, which resulted in 10 being successful, having ILG certificates issued and 21 pending. 22 applications were assessed and are incomplete, pending sketches and other requirements to be met prior processing. So these ones are sent back to the clans who intend to register as ILGs to meet the pending requirements and come back with their applications. For VCLR, the provincial office does not have copies of issued customary land titles. Also, there may be about 5 issued for the province. Number 4, instances customary landowners engaged with investors prior execution of the ILG and VCLR or LTC process, so they are paid in advance some form of capital that will cater for their ILG and VCLR or LTC process expense.
Sorry, Ms. Wan, can I just interrupt quickly? Not to interrupt the train of thought. After the provincial moratorium was raised in 2019 so far, 2019 is how many years ago? 6 years ago. In the space of 6 years, you've received only 55 applications, ILG applications, 31 assessed and further lodged with you have
Registrar of
10
ILGs.
successful, and 21 pending, 22 applications were assessed. Why do you think such a only double figures in 6 years?
Actually, most of these ILGs were ready to come forward to lodge their applications, but in the province we were cautious on dealing with or having to process applications that may have some form of effects or create disputes among clans back in the rural areas. So at the provincial level, we formulate our own what we call the ILG audit template. So in the process of vetting off the applications that come through our division office, my provincial customary lands officer has to use that template to check off all the applications prior I sign them off to the department.
Do you have is that ILG audit process template in this information sheet?
No, but I can furnish you a copy.
Thank you very much. That will be much helpful. But
thank you.
You have a question?
Thank you, Ms. Guam. I'll just go back to the growth centers. You mentioned something about the funding issues, which obviously is an issue. And then I'll come back to the voluntary customary lands. In the East New Britain Provincial Economic Advancement Plan for 2024 and beyond, where does land development, land administration sit in their priority? Is it the first priority? How many priorities, strategic priority areas do they have, and where does land sit?
Okay, in the province we have about 9 strategic result areas, and land mobilization is SRA number 7, sorry. SRA 7 is land mobilization.
So can we say that because it's sitting number 7, it's not getting the attention by either the provincial government, if land is an important matter for development?
Indirectly, that would be a yes.
In terms of budget, the division's budget for a year, can you give us some estimate of how much funding the provincial government allocates? Maybe not so much of the recurrent, but for the development aspect.
I would not say much on the development budget, simply because there's not much support. I'll just generalize it. There's not much support on land mobilization development programs in the province. So the approach that the sector is taking is to work along with respective district administrations, seeing that which development project falls on which district. We lobby with these districts to fund the program and we deliver for them. That's the approach we are taking. So if one gate is closed for us, we look at the other alternative to work with. So it's working for us in this way.
You wanna? Okay. Just coming back to the ILG and VCLR experiences. You mentioned here that the provincial office does not have copies of issued customary land titles, although there may be about 5. It's an assumption. Reading this indicates to us that you have no control of the records. The records could be in Waigani, and there is no record in the province. So my question is, how do you keep your records? Or do you have to go back to Waigani every time you have issues or issues raised by ILGs or customary landowners? Because obviously that's where the bottleneck is in terms of giving quick feedback to the resource owners. So any reason why you don't have the records?
One reason is our regional office was once in the province, and with the VCLR process, the landowners deal directly with the regional office and they bypass the provincial office. So in that regard, when the title is issued, it's the process flows bypassing the division office, going straight to the department. So when we have issues arising from these clans or ILGs now, that's when we try to reconcile our informations with, or our files with our mother department to confirm whether or not these titles were actually issued.
Okay, thank you, Ms. Guam. It's a concern because I think earlier some of the evidence was that the process is always shortcut because maybe the ILGs don't have the answer here, so they take the shortcut process as well. I think, Chairman, that's basically it. Yeah.
No, thank you. While on that note, quick question, a clarification basically. In point 1 of ILG and VCLR experience, you state that the customary land that is still customary in tenure. The focus in customary land administration being the recent paradigm shift or being the more trending,
Yeah.
having to encourage customary land owners register their customary land that is still customary in tenure. What do you mean by that, customary in tenure?
A land that is still customary. There's no form of acquisition or alienation over those land parcels. They're still customary.
Or there is no
status.
document?
Yes.
Just any document, for instance, just no title, no document, informal, still not within the state lease areas or freehold.
That is correct.
So basically, when you say customary land, we are saying not documented, correct?
Correct.
Next question is, this VCLR process, what is that legally underpinned by? This voluntary customary land registration, what's the process? I mean, what law looks after that process?
The Land Registration Act 2009.
Okay. And when the title is issued, what does it look like? Does it have what's the title? Certificate of title? Certificate of customary title? Or what's the name? And is it for a number of years?
It states customary land title on it.
Okay.
Yeah.
And then I think I'll hold a thought. That would be question reserved for the bank. What does that mean when it says customary title? Is it perpetually open or for a number of years, or what does? Can you explain?
Okay, I have not gone through the actual conditions or the covenants in the title, so I will not answer that. But if I happen to get a copy of the title, I will explain.
You can take note of that question. Maybe when you come across one, you can, if you could submit as an example, just for, you can plot out the,
Yes,
you must cross out the name of the benefit of the ILG, and also if you like, you can cross out the other particulars. So we, for the
Right of privacy.
confidentiality,
Yes.
privacy law.
Yes.
But you can surrender, it's in principle, we can see what it looks like,
Yeah, correct.
if that's okay. Next question is, are you aware that once such a title is issued, is there an additional instrument or process that a leaseholder, a title holder can use? That's the VCLR process.
With the VCLR process.
Yes.
I won't answer that. Sorry. I'll just take note of it.
Thank you. If you can take note, if you come across such an instrument that arises or that could arise out of a certificate of title created through a VCLR process, that would be of great assistance. And again, in that situation, if you don't mind, for the privacy and rights of beneficiaries, you cross out particular of the area and also the name. We can just see in principle.
Yeah. Okay.
Thank you. Follow-up question.
Ms. Gom, I got a follow-up question. Just going back to the template that you mentioned that is used to screen the ILGs. I just wanted to get some legal clarity whether this template is sanctioned by Lands Department to assist you in making your assessments, and if it's helping or it could be a hindrance or barrier to getting the 55 applications processed because of the requirements in the template. Because 6 years and we were able to get only 10 ILGs. So what are some of the major impediments in the process?
Okay, thank you. The first question is in regards to the template. The template is not sanctioned by Lands Department. It's sanctioned by Provincial Executive Council. There was an actual submission done together with the template, and it sought the government blessing for us to use it in the province. It's actually we use the ILG Act to guide us in formulating the template. So by using the template, to the second part of the question, by using the template, it kind of guides us to identify the issues that we have with the sketches and the membership listing. Those are the critical areas that we identify issues on, as well as a few issues picked out on the governance, having the ward members of another ward signing on the applications. So all those are picked up, and the applications are referred back to the clans to improve them and resubmit them again.
Thank you. Ms. Guan, I think on this, maybe this will be the last part of this section, and we'll move on. So bear with us for a bit. You stated here that instances And the fourth point, customary landowners engage with investors prior to executing the ILG and VCLR or LTC process. So they are paid in advance some capital of outlay that will cater for the ILG and VCLR or LTC processes and expenses. It is now a norm that we don't have control over such arrangements. However, when problem occurs, landowners or investors seek assistance of land sector to correct the process and ensure compliance, or even to the extent of going to the courts. And
Yes.
number of things happening here. One is this, I want to ask, do you think it might be of great assistance if, are you suggesting here the state is not proactive in assisting, in facilitating registration or formalization of land?
Yes, that's one. Two, we need to help the customary landowners with funding. Specifically, when it comes to surveying, it is a very expensive component for the very customary landowners, people who are just farmers.
Maybe not funding, because that might be a very scarce resource too, but maybe capacity. Right? Maybe have surveyors ready on standby who serve the state's interest and the interest of the people whom we represent. They could go out and do the job FOC. And the state should pay for it, correct?
Correct.
Yes. So that would be more support and, sticking to standards and
Yes,
and
compliant
consistency.
systems, yes.
So people, landowners or developers are not left to private
Fend for themselves.
Fend for themselves. I agree with you.
Chairman, can I ask a question?
Yes.
In terms of survey, how helpful is the Lands Department?
Thank you.
No, the
I was
Lands
gonna
Department.
propose something here. Lands Department does have a project division, but looking at the normal business process which our customary landowners are following, there's no support from the department to help them. And I'm just of the opinion, if we can consider having a project division, not division, but a project section within the division, specifically to help in that regard as well.
It's a very good recommendation. We'll take note, and it also goes to the question of availing capacity to at the provinces and the decentralized process.
Yes.
Everything is sort of bottlenecked at Waigani, or maybe that the vision is lacking, and so the implementation is is now problematic. If you see what we're going at here, but it's a very important part, bits of the state's responsibility to her people. And you're raising some very important critical points. It's the norm, it's become a norm. So obviously, registration is only attended to if there's a project. Now suppose you got project, your land is at risk of squatting. Maybe not here in the New Guinea Islands, you're not facing it a lot, but in Port Moresby, this is a real problem. In Ley, it's a real problem. Even Mount Hagen. Across the nation, in urban centers, peri-urban areas usually are secular spaces, land around state titles, because there's no formal representation of claim or ownership. People are at risk of squatters coming and just sit down on like long. No, to stop 10 years, 20 years, 30 years, now come up papa ground somehow. Also talk, hey, we plug out user rights. No! When am I blue user rights? This is the problem. This is why these gaps are, it's frustrating. Yeah. So I'm thankful to you for raising these very, very important points and recommendations. I'll let you continue if you don't mind.
Thank you. We'll just move on with the presentations. The next slide is in regards to cost involved in the ILG process and the VCLR process. Next slide. Yeah, that's the one. With the NID, it's to do with membership. Of course, there's cost involved. Sketches on properties, of course, there's cost involved. Applications to be lodged, there's cost involved. ILG certificate issuance, there may be some cost involved. With VCLR certificate issuance as well, there may be some cost involved. With 4 and 5, why it's yes or no, given if the clients are supposed to pick up those certificates themselves, then we have the travel expenses from the recipients of the certificates. With VCLR, definitely survey will have cost involved, likewise the title. Now in the event there's dispute, then we go to the land mediation process, and of course there are costs involved that will be incurred by the disputing parties. Okay, next point, TNB's economy is mostly supported by agriculture, and most ILG members are local farmers who raise funds from toiling the land to fund their ILG and VCLR expenses. The next topic is on integrated rural development projects, so we call them IRDPs. IRDP in the East New Britain Strategic Development Plan is a version of putting SABLs and FCAs together in administering land for development and improving livelihood of rural communities. SABLs issued over vast customary landmass for dual purpose, being one is for forest clearance authority issued by National Forest Authority and long-term agriculture land use. SABL SABLs are organized through landowner companies. Number 3, partnership between landowners, investors, provincial government and national line departments including PNG, FA, DAL and Department of Lands and Physical Planning, Department of Agriculture and Livestock and Department of Works are the missing stakeholder in these IRDP initiatives. With SABL being the controversial, there is need to convert what was issued under SABL to customary land title through the VCLR process. So landowners must have definite ownership over a legal description that has a defined boundary. This is the security landowners will have over their customary land, though finance institutions still see customary land title, not a collateral for loan. On the contrary, those investors from logging, FCA to agriculture development who already experience economic potentials from the project, they shall continue to assist the landowners until VCLR process is fully executed and title is issued. The arrangement will be agreed on by the landowners and the investors and captured in the binding agreement between the investor and the landowners. The FCA initiatives under IRDP, we've listed 14 there. Those are the project sites for us in the province. PNG Forest Authority at Kerevat Area Office recorded 14 FCAs for East New Britain Province. These integrated rural development programs from the logging has embarked on agriculture.
I'll just interrupt you. You raised some very critical points here. You said that SABL being controversial, there is need to convert what is issued under SABL to customary land title through VCLR. At this point, so landowners must have definite ownership over legal descriptions that is a defined boundary. And then you got a list here. Are these projects, do you have an indication if any of them are under SABLs to enable it the capacity to operate in those project areas? And from the top of your head, are you able to point us which ones are which?
Yes.
Okay. So Makolo FCA, does that have an SABL?
No. Makolkol FCA.
I'll allow you to go through it. Which one would you pick out?
Number 8.
Number 8, Sigatemukus, SABL.
Yeah.
What else?
Number 2, that's Toriu.
For you,
And 11.
11, Simbali. Are these projects current?
On the status column, some have expired and some are current.
Oh yes, you have said.
But this list was prepared 2 years ago. If we update it to today, we'll get a current status of the others that are current, if they have expired or not.
Okay, but there was you remember the SABL Commission of Inquiry?
Yeah.
Have you ever read that report? Had the ability to, have you had access to it?
Yes.
Were any of these SABLs listed in that inquiry by any chance?
There are a few
Okay.
listed in that report as well from
In
East
East
New
New Britain.
Britain. Yes. There's a report as well we've done from the office, and it's quite thick, so we'll just make you a copy later on and submit.
Thank you. We'll take note of the list that you provided, but can I ask you to move on?
So we'll just move on from the list that is there. The FCAs that are listed on the table there are actually references from the Forest Authority. So we'll move on the economic benefit from the FCAs. Under FCA, we have log export development levies that are paid because these projects are implemented within the boundaries of Gazelle and Pomio districts respectively. The log export development levies are paid to these 2 districts and also paid to ENBPA. The project development benefit levy is for Iliwawas and Ili standalone FCAs. Provincial government levies are paid by the investor, being those listed there: KK Connection Limited, Guilford Limited, Pacific Development Resources Limited, Greenpoint Limited, Chen Eugenie Limited, Wanimo Jaya Limited, and Mekar Limited. Other levies include LLG levies that are paid to respective LLGs for impact projects, and district levies paid to respective districts of impact projects.
So these benefits are prescribed by the project management agreements.
Project, yes.
Yeah.
So to the landowners, royalties are paid on various rates ranging from 10 kina to 35 kina per cubic, paid direct to the landowners through the PNGFA. The premiums for the management of the landowner companies, levies through the landowner company as per the logging and marketing arrangements, and the terms and conditions. Log export development levy or LEDL are paid through respective districts, specifically Pomio and Gazelle. The project development benefit are paid through the committee and the PNGFA. Domestic processing benefit is paid to the landowner company, and infrastructures such as schools, aid posts, churches, community halls, library, water supply, roads and bridges and culverts are constructed on the project sites. The other benefits includes employment opportunities, school scholarship opportunities, improved lifestyle, solar lighting at home, land cruisers, trucks, boats, walkabout sawmills, balsa, camarere for long-term revenues and revenue for the locals.
Chairman, yes. Thank you. I think we were just listening to some of the important issues and of course development and assistance from the companies. But can I just ask a question here and raise the issue regarding the environmental effect? Is the provincial lands in East New Britain considering the environmental effect through those developers? And as we all know that SABL, is just like what you mentioned, is a controversial issue, and my concern relates to, the effect. I know the government has cancelled many of the legal SABL list, but have we made or held those companies, especially in logging and agriculture, it's like what you've mentioned, sectors accountable for environmental damages? Lands, as through the presentation in Mosby and of course, with forestry and environment and conservation. I mean, any projects that we need to approve and give to companies, the environmental effect must be considered. Is there any working collaboration with those relevant authorities, or lands just giving the land just because of the sake of development in the country? Thank you, Chairman.
Okay, thank you. That is one gap that the department has to work on. Department and all the provincial, especially us in the province, to work together with the other line agencies to improve on how we execute our business, to ensure that we take on board those measures to be part of the agreement that is between the landowners and the investors.
Yeah, thank you. Remember, very important question raised there. But just from my corporate knowledge, what happens is there is environmental impact assessment report attached to the applications, right? And so that report usually contemplates, prescribes whether it's the project is environment that ticks all the environment boxes, and as a prerequisite to final grant. The question therefore is the conditions subsequent to grant and review process. I suppose that would be a review matter, and it's a question of, I suppose, that with the relevant agents on the ability to do the monitoring and evaluation of the environmental impact pursuant to the report, because the report is done before DY put down. After the DY put down, in actuality, then I suppose that is a question only conservation, environment, and conservation can answer based on physical inspections. But again, with the relevant officers, I guess they can answer the question. But we take note, very important. Everything in this country, we can have many laws, but also implementation.
Yes, true.
We can also have many laws, but everything is centralized again. So I think this will go to the other issues of decentralizing functions or powers and capacity of provinces. Because the country is not in Waigani. The country is how many 100,000 square kilometers of land and water and sea. So if this is something that you may think.
Thank you, Chairman. Well, just for a little bit of clarification on this, I picked up something in Mosby through the presentation of the environment and conservation. And then it relates back again to the ILGs.
Yes.
Chairman, I think this is a very important issue. And of course, with land, you cannot build, anything on top of the land without, consulting the relevant authorities.
Very true.
And while here in East New Britain, Chairman, I'm not talking that because I'm from East New Britain, but talking on behalf of the silent majority. Chairman, bami to kolsem, lo tok pisin. Time me ask him this environment, and me to kolsem. He's standing on behalf of the one that's supposed to be there and giving us the right information, but and everything relates back to the ILGs. Na me to kolsem. Only be him tasol tok bloman where he got paper long ILG to kem ground blomia. He said that. Na me ask him na you consider him to side effect lo desela environmental side effect in the future. Na emikirap na tok yes, but me play him tok tasol long ILG. Chairman, that's what he said. Because MPP is tap long and we can bring him development. So it goes back to lands giving ILGs without consultation with the other, clan. Now behind heavy come up. So this is my concern and my question as a member of this committee.
Very, very valid concerns and very valid observations. And so this is the observations already made thus far. And you're also validating some of those points. So thank you very much, Ms. Guan. If I'm all right, you make...
Continue.
Yeah.
Okay. Thank you. The next slide is on benefits to landowners from sublease arrangements. Land lease rentals. The annual rental fees are paid per hectare to the SABL holder, which is the landowner company, over areas developed to agriculture products and associated infrastructure developments. The umbrella or holding company is paid certain amount of rental, usually lower than what is paid to the landowner company. Undeveloped or conserved areas attracts development levies, also less than the annual rentals. Note that the ILG does not benefit. The 5% FFB or 5% from the fresh fruit bunch, this is in relation to the oil palm development, is calculated on farm gate price during harvest and is due payable to customary landowners from which the palm is harvested from. Moving on, the SABL challenges. The SABL arrangement is not clear, never cited, and issued SABL title to the landowners. However, documents only reference gazettal of the SABL projects. The SABL issued to landowner companies and not ILGs, thus direct landowner benefits not enjoyed by the true landowners, instead the landowner company. Number 3, need to calculate total land area of all SABL project areas. And number 4, need clear information of land tenure status for SABL in such integrated rural development projects.
On that point, you raise a very, very important one. So in this sort of projects, it's saying that benefits are not cascading down to clan members, even in operational project areas. And these are because, if I hear you correctly, there's a lead capture through the SABL system, and the landowner company as a legal entity is a lead capturing benefits, and it's the frequent occurrence that these benefits are not distributed to the clan members. So this is a gap.
Yes.
I think you are suggesting. This is a gap where benefits are left at the behest of directors of a landowner company.
Yes.
Okay. In a situation, in terms of reform, if the clan landowning system was corrected, you were suggesting that if it was corrected, then let's say an ILG, or in this case, let's say a clan. A clan would have a formal identity, right, under the law.
Yes.
And the clan will then have a list of all its members, right? Supervised, of course, by a state entity, maybe an authority, maybe. So not only for residential purposes like the scenario Mr. Kubak raised earlier, but also in this sort of mass projects, commercial projects, then the benefits that would be paid through the authority to the clan would cascade automatically directly to the beneficiaries.
Yes.
In terms of royalty especially, maybe a certain component of the benefit. So the landowners don't miss out in this lifetime,
True.
as opposed to waiting for the big dream investment strategy by the landowner company, which is not wrong. Maybe it's there's some good thinking around that too, but in the meantime, not everybody's going to live forever. So we need to maybe be innovative in this thinking of a legal prescription into the future. So if the land issue was corrected, every development on land would be, aligned. But this is what the gap is in the law. So you have all sectors, including oil and gas, mining, forestry. You're using a forestry case study as an example, and many others. Thank you very much. We push on with your presentation.
Thank you. The issues identified by experienced by its sections within the division start with alienated land section. The administration of plantation is a mammoth task for 4 officers of the section. The administration of land board, administration of agricultural lease compliance versus provincial economic aspiration, administration of rural and urban state lease from one position is a mammoth task. Ensuring physical planning decisions to zoning does not affect the existing leases. That's from alienated land section, which deals with state land and freehold land as well. Customary land issues and challenges. Proper land acquisition for education and health sites, road infrastructure, and community area sites for public use or purpose does require effective communication and dialogue between the LLG administrations, district administrations, Division of Lands and Physical Planning, as well as Department of Lands and Physical Planning. Number 2, ILGs to continue with registration of their properties through voluntary customary land registration process and ensure customary land title is issued. Also to continue registering their properties. ILGs to continue registration of their members through NID and amend the list of membership. The annual general meetings must be conducted and as and when is due, and reports submitted to Provincial Lands Division Office. All ILG executives are subject to be replaced after completion of their 3-year term. Changes of executives is through a full AGM in the 3rd year. No annual reports received from registered ILGs by the Lands Division. And customary land section capacity is only 2 positions, that is customary lands officer and land acquisition officer. There's no ILG or customary leases officer. There's need for an increase in staff strength. The only workshop conducted for ILG and VCLR business process was in 2012. There's need for a fresh training course for newly recruited officers, as well as latest amendments or requirements by Lands Department. On physical planning challenges, there's new developments for Kokopo and Rabaul in rapid phase. Also, Palmalmal development is picking up. Number 2, human resource capacity is outweighed by the workload that we have, and there's daily needs for logistics. For valuation challenges, the workload outweighs the staff capacity. We only have 1 valuer. and there's need for registration. He's only a graduate valuer, and the daily need for logistic support. For survey section, there are a couple of issues and concerns raised on professionalism. Most graduate surveyors in the field practicing over a decade and are yet to be registered. That's the current issue we have. That's why we have limited registered surveyors in the field. And uphold the quality of standard for the production of cadastral plans, one standard for all. So the proposed improvement we have on the last column is to have an institutional similar to LTI to enable all surveyors to register within a year after graduating bachelor. The institution will also register certified measurers to ease the rising number of ILGs and VCLR process, and the review of the Survey Act, review of the Survey Coordination Act, and the survey directions. On mapping, the cartographers and GIS graduates are producing maps that are not to the best interest of the surveyors. Mapping done are for planning purpose and sketches for ILG property listing. On a proposed improvement is for cartographers and GIS graduates to undergo training and be registered professionals as well. It will improve the quality of output in mapping. Moving on, should cartographers and GIS graduates have a separate institute or association, or should they be part of Association of Surveyors PNG? That's one concern raised. Moving on the institutional strengthening. Abolition of Department of Lands and Physical Planning Islands Regional Office will result in certain services being rendered at a much higher cost than ones at regional office. These include assessment of new survey plans, issuance of catalog reference and mapping, certification for ILG sketches. Circulars and directions from Secretary's Desk or Office of Surveyors General must reach all provincial office to improve communication linkage. On the proposal, Department of Lands and Physical Planning should have done a wider consultation prior making the decision. Therefore, we call for Department to revoke its decision and call for Islands Regional Office. The review of the MOA between Lands Department and East New Britain Provincial Government for capacity building, and we require decentralization of functions by the department. Also, one option moving forward is Office of Surveyor General to be prioritized to an authority. Another key area is Association of Surveyors membership, the classification of membership in ASPNG. It's to do with their qualification into the association, and the question of if the other professionals can be part of the Association of Surveyors PNG.
Chairman, just for the benefit of the public and people of New Guinea Islands region, regarding the the National Lands Office that was brought back to Port Moresby just because of rental. But for the benefit of the people of NGI, this is the center of New Guinea Islands region. Can the advisor just say some more clarification regarding the closure of the National Lands Office here in East New Britain, and now taking too long for the people in New Guinea Islands to travel back to Port Moresby, or bringing back Port Moresby to Port Moresby. Enough, you just elaborate more on this league. So all people in Masabel same lands even go back, national lands even go back, losing province loyal along its neighborhood, because just now you mentioned maybe rental been high too much.
Yeah, thank you, Ms. Gom. You can give us some feedback on why it will go. Rento ligado al naraplarisian no.
Sorry, I'll just be frank here. All regional offices throughout the country are closed, and all the regional offices have been moved back to Lands Department. So if that's all I can say for now first.
Okay, thank you. We'll take note for the committee to pursue further. Then continue.
Okay, moving on, the other key area is on survey cost on land groups. There are fee charged on sketches and fee charged on subdivision survey work. On proposal, if those fees can be reduced by 50% to encourage ILG and VCLR process for our local population, and review of MOA between Lands Department and the provincial governments. Moving on, the challenges for the division in general. Although land mobilization is a prerequisite for any social infrastructure or economic development to take and as well silently contribute to the national revenue through ensuring state lease compliance for annual rental dues are paid to the state, Division of Lands and Physical Planning is one of the least prioritized sectors comes budgeting and allocation. Number 2, need for more staffing at the provincial level. Number 3, project section need to be established within the provincial divisional structure. Number 4, district land sector capacity to be increased from 1 staff to at least 3 officers, and logistic support to district lands coordinators is a need. On conclusion and recommendation, all sections within lands division or land sector has a role to play in land administration as well as land development and management. It is paramount to ensure that all our works are carried out in accordance to standard and in compliance to law we administer. This includes land administration and land development management. Through various divisions in Department of Lands and Physical Planning, who is responsible for standard and compliance, there is a need to develop a career development pathway for our volumes of graduates to being registered and licensed to ensure work are done to standard. If we have volume of professionals in the field, we will ensure quality work output without much supervision. Number 4 is on teamwork. If this the list of stakeholders to work together, that's East New Britain Provincial Government and its administration, Department of Lands and Physical Planning, National Mapping Bureau, Department of National Planning, National Lands Commission, or Lands Commission of PNG, Civil Registry and Government Printing Office, and as well the other stakeholders. 5 officers to work towards registration and licenses through Association of Surveyors PNG, PNG-IVLA, Association of Physical Planners PNG, Surveyors Board and Valuers Board. Second last, lands sector officers in public service to have CMM certificates at least or diploma in public administration to ensure professionalism in public service as well. And finally, logistic and funding support for the land sector is a need. Okay, to my final slide, if customary land mobilization reform is a way forward, we all have to work together. Thank you.
Madam Lands Advisor, thank you for your contribution. We will read this notes or submission into the material, and with any questions, any further questions that arise, we will come back to you either through the course of this discussion, so don't leave, or at a later date. But in the meantime, I think in the interest of time, and I think one of the biggest stakeholders in this entire conversation is banks and financial institutions. And I have with us Ms. Kala Triman and Ms. Stephanie Aini, but we can continue with the conversation. And I want to, ma'am, thank you for accepting our invitation to contribute to this very important hearings. One of the biggest things in this country is the lack of security, or our people's inability to provide security. Generally, that's the discussion. So, this conversation is not relevant if this other component, very important component, is not, addressed. So, I welcome you here, and I think, to be on the record, you are the first. So, thank you to the management and team of Kokopo Bank of South Pacific, and through you to your head office and to your leadership team at the Bank of South Pacific, allowing you to contribute in this conversation. So I welcome you that, and welcome you when I make those special remarks. I want to ask you, obviously you've heard some of the comments and points made by the Provincial Lands Officer. And in one of these areas, she makes mention of certificates of title, which we'll come back to. But I think at this point, I want to just invite you to state your name and your position for the record, and then we can take it from there. And if maybe allow you a free flow of discussion so you can contribute. You have a space of really, I'm trying to limit it to 10 minutes, 15 minutes, but the last segment was critically important to lay the foundation of this discussion. So you will not remember, but if I can allow you some time to contribute. Thank you.
Thank you. Firstly, my name is Kala Tiriman. I'm the branch manager for BSP Kokopo, and I have my lending team leader sales, Stephanie, with me. Thank you so much for the invitation from our member here for Kokopo. Basically, with land, in line with the bank's policy, in most cases we have customers coming into the bank, and basically in most cases they're lodging their applications for home loan, and so in line with lands, we take land as a security over the application that the customer wishes to lodge, and basically we mainly look at estate lease land. So currently we are assisting customers that have land at Keravat, Kokopo, Kinabot, Rabaul, and Tacubaro, Seaview. Maybe soon we can be assisting Palmalmal with that, but currently we are assisting customers that own land around those areas. Unfortunately, we don't accept customary title. Basically, it's because customary land they are owned by a group of people, and there's uncertainties there when it comes to default. It's difficult for the bank to take back the title. Take back the land from the previous owner. So with state lease land, it's easy when we have to take on board the file, and there's a new interest, new buyer there. It's easy for us to transfer the title. So what we do is we have to confirm the genuineness of that title, and so we do our own search with Department of Lands in head office. They do confirm the title, the genuine owner of the title before we proceed on in assisting them. And secondly, we value also the land before we actually assist the customer. So there we have to engage a registered valuer to value the property prior to processing the application for a customer. Thank you.
Thank you, ma'am. Any questions? Anyone? Maybe I take my cue from that. Ms. Kalat, the question is this. The certificates of title that have some been presented to you in the time that you've been serving the bank, some of these titles that you are rejecting, have they been presented to you in proposals brought by applicants? Have you considered some of these certificates of title, customary?
Customary, no.
Okay. You know the VCLR process that the lands officer referred to earlier, and the certificate of title issued under it. Have you ever come across one?
No, not yet.
No one in Kokopo office has seen one yet? Okay. But obviously customary land, when you say customary land, land that belongs to clans, the people. But obvious group of people, you said. But it cannot be brought forward because there's no document that represents it like a state lease does, correct?
Correct.
Okay. The state lease, I'm just going to digress a bit. We'll have a conversation on this. State lease, who is the state?
Yeah.
Who? People,
Yeah.
People, 10 million people of this country. So we're disputing the numbers now at this table. This is 12 million. So all these groups of people are represented by the state. And through the state, this lease for a number of years is produced. So on the state lease, you'll have a number, 1999. But there's a presumption the land is state lease, state title. And then, has anyone ever seen one? The head title. Maybe in some cases, others, some have. I have not seen one. What I have seen is a state lease out of that state title or state interest. They produce it and then has a numbers, SLV, state lease volume and folio.
Okay.
At the bottom is the cat number, and then you got the section number or portion number. And then they have the conditions. You must build a fence of the value of 100,000. You must pay rental for 12 months, every 12 months for 3,000. You must, and there's a condition like list. That's what a title is. And that's what the bank takes, Who is to say that clan land should not resemble similar process? You think in this case, you're not speaking for the bank, maybe, or qualify you're protected. So maybe, do you think as a Papua New Guinean and a banker, of course you raise a very important point about foreclosure or remedy in the event of default. But, ma'am, if an authority was set up by the state, by the government, under a law that sets out all the provisions that relate to customary ownership of land in this country, and it pronounced through it that land set up two things. One is a registry of clans. Obviously, we will all register. We got NID, and through our NID and our groups, we have clans. And the clan would be given a legal personality, also ILG, but even more stronger, bound by practices and observations of our Tumbuna, but within that. It's a legal person, like a company, like ILG, legal person. But by then, maybe ILG might be done away. And then, second register the register of property that belongs to the clan. So you walk outside, there's, as far as you go, you find somebody says, this is Noga title, M Customary land clan from this area. So after that is set up, the clan land is represented through a title, like a certificate of customary title under VRC, similar to that, or maybe that could be it, migrated into that. But that is not, that would be the land interest in favor of the clan. Forever and ever and ever and ever. Now you're going to ask me, but Mr. Idu, you're not answering my question, you're not curing my problem. We're still left with the question of enforceability. That clan still, that land still belongs to this group of people. Only difference is that by this time, this group of people who are clan members, who own this thing together, are now traceable. You can find them on the register, real people who have authenticated to be members of the clan. But the title is perpetual, that's the word in English, forever. And then if an applicant came to you with another document that sets out part of, or this parcel of land that was part of that certificate of title, with a catalog number, survey cat number, resembling the state title under the torrent system. But it's actually belonging to the clan, forever and in sake of time. And this title or lease agreement should be taken, could be taken to the bank, because it's only for 50 years or 30 years, whatever the clan said, however long you can stay. And it's got conditions again. You have to pay rental every year to the clan through the authority. You have to build a fence. You have to put these improvements, the improvement covenants, rental covenants, and all these conditions are attached to the lease agreement. And if that is done, do you think that could be securable? That's more, and in the event of default, you have a choice. We trigger a process prescribed by law, whereby banks and financial institutions can get their money recovered. Maybe in the clan, through the bureau, through the records, one of the cousins is doing well. So you resort to them and say, come and manage this thing for them until you pay them out. So the bank's interest is just the debt. Yeah. The bank's interest is not the physical land. The bank is going to one day be wound up if it's liquidated. So the bank might come and go. It might change its name later, or buy another bank and get bigger, or sell its bank and be smaller. But the land is always going to stay, correct? So if this scenario was provided by our law, you think our people in Papua New Guinea the bank might be more responsive, favorable?
Yeah.
Yes?
Yes.
Let me ask an open question. You can pan the camera if you like. I want to ask the audience today. Suppose you make this like and walk about to change the law in this way, or provide the law in this way. You think this might work? It might work, huh?
Yeah.
Mr. Kubak, as a professional practitioner in the law, what's your view?
I've actually exercised I was saying, I've actually exercised my mind to this very issue over the years, in my years of practice. You rightly told the good bank manager that the bank's interest is really, recouping the balance of an outstanding debt. It's not really interested in the land. Yeah. But if there was a system in place provided by appropriate legislation that enables the bank to put in what you would call a manager, who would be interested in, say, if the land concern had been obtained and had been used for agriculture purpose, say to plant balsa or plant some other. And the bank was in a position to secure somebody interested, possibly in the same space, in this portion of land, in managing this land, and with the ultimate aim of giving back the bank what is due in our state. I think that would be feasible. I'd say that is a system that would appeal to the bulk, if not the majority, of our people, who obviously are members of a clan and they own land.
Yes.
Yeah. So that's that. Now maybe when I have this opportunity, or I've had this particular document in front of me and it's been opened to a page that I wanted to get
Yes,
through.
please.
What I have here is the organic law on provincial governments and local level governments. Section 42 of this organic law, which is dated back to 1998, gives the provincial government as well as the local level governments lawmaking powers. I'm particularly interested in what powers have been given to the provincial legislature by Section 42, 1, letter R, and I'll read it for the record. It basically says, subject to the Constitution and this organic law, a provincial legislature may make laws on the following matters, and I come down to the relevant part. R, land and land development, including provincial titles. I've never seen a provincial title as yet, as I see it here, but anyway, that's what. And leases, provided that the terms of such titles and leases shall not exceed the terms of titles and leases which may be granted by or under national law. This is the answer to much of the issues. I stand to be corrected, and I think my good member will have some idea, but I stand to be corrected. I have never seen a provincial land law as envisaged by this particular provision, in this province at least. There may be in other provinces, but here I have yet to see one. And this is not the first time I'm raising this. I've raised it elsewhere in other forums in a past number of years. Nobody seems to be paying attention to it. But this is with the VCLR and all this. Ultimately, it would end up in our very own provincial office here, registry office, land registration office, and all the other necessary relevant offices for purposes of this very section.
Yes.
Thank you.
Well, no, Mr. Kubak, very interesting pointer there. One of the problems perhaps draftspersons or lawyers have had is the fragmented nature of the various laws in this country.
Yes.
Because I think if you go back and read Section 42 again, and relevantly R, on land and property, it qualifies it again to, as long as it does not, it's nothing different to what the state lease provides. It has to be, there's a contemplated or intended conversion process, and ownership eventually must sit with one person. This is what the law is doing at the moment. It's cutting out everybody else. So it's likely that only the head of the family or head of the clan, his name might be on the document. That's the risk maybe a lot of people are having. Also, it requires it's a bit of a process, and like I said, gymnastics in the law to try to get through it. So I guess this is why, for whatever reason, I too have not seen one provincial title or provincial law in terms of land, and this is because provincial law, land law would pose the problem of formalizing to a singular owner at the expense of the masses. Don't forget, the lawmaker in this case is the politician. And at the ground level, when one tries to implement a singular homogeneous system, it can create there's a big backlash. Now me? What about me? I just missed out. And because the clan is not even a legal entity, or there's no real mechanism formalizing clans. ILG, as we are pointing out, might be a solution. You're saying, oh, but ILG is there. Again, I think throughout this discussion, we're going to start noting that the ILG's shortcomings are the big problems. It's in the same way, adding people who are not entitled to be part of a clan, or removing people who are supposed to be in the clan, and denying people relatability to fiscal land. So many other issues, but interesting points that you make. There's been a lot of discussion, a lot of research around this very question that you and I are all troubled with. But I think there's a pathway. And in this pathway, it's going to take a bit of, this is the social contract that is required. If the people are resoundingly of the view that their clan should be accommodated by law, and through the clan, this way the clan will never lose, first of all, you are recorded in history and forever in time. First, this is important. Which means our customary practices are given a breath of life again to continue. Otherwise, we stand to be endangered. Number two, it gives you the ability to hold on to your property forever. Even after you die, it remains with the clan by sanction of the state. Number three, it gives you the ability to create security or ability to create credit for yourself and raise a debt for development, for even to just build a house, a decent home. And every man should have a shelter. Why not? And woman and child. So this is hopefully it's going to push a little bit of boundaries, but I think long overdue. You know, the torrent system or the stately system is from the English tradition. I'm custom law white man, custom law England. Who said to me, come through long. Australian only come law here. Custom passing master. Well, why are we borrowing these ideas when we actually have our own ideology of owning property?
Correct.
And why must the bank not want it? Let's say, for argument's sake, BSP's market interest is big, big ticket item, big projects, big money. But you know, you have micro banks, People's Bank. We have the nano banking sector, financial sectors that are now sprouting. Apparently, it is the growth mechanism in some nations like India. Why are we afraid of formalizing our pasintumbuna and our way of life into law? We have to breathe it into life. So, no good me end up torma blasemon lawyers. Mami, only thing blow me. Now, today is about you and to hearing your views. At this point, I think we've had quite, there's a lot more important people in the room today. So, if we can take a short recess, allow you to, refresh. There's some lunch here. Enjoy yourselves, and we come back and say it's 1:48. So I'll give you. It's quite exciting. So we were a lot of speakers here. Maybe 30 minutes.
Chair, before you go along coffee or lunch, late lunch. Thank you, lawyer Kubak, na deputy governor, na to Lens advisor, na to long manager long bank Yumi. I think a very important issue that our good council have raised, according to the provincial and local level government. This is something that yes, the committee will take note of, and that's where it's very important regarding the decentralization of powers or delegation of powers to the provinces, and like what the good Prime Minister have announced, according to the autonomy, and that is a way forward for us. If other provinces are not prepared, we are prepared here under Chairman through the administrative powers the provincial, the financial powers and the political powers. So thank you, Council. I think mibla by nidi mulo disla with the committee. Lo sampla legal advice with your colleague member here before. But thank you. Regarding the state titles, of course, there are a few issues that we are facing now, and Kokopo now is embarking on giving titles to some of the title holders, which they have stayed almost for 47 years. And while saying that, my good chairman, yes, there is a lack of financial support, but under the partnership through the stakeholders, individuals in the district, we are now partnering with them, and of course with the funding, 600 kina, and the government is putting 600 kina. It's quite a bit expensive, but at the end of the day, they will receive the title, and that refers back to the manager regarding the title. This is not a customary land; it's going to be a state lease, a state land, state title. So all people blame me now. Supposedly, kisim this la title long maybe this la independence celebration. Lo bank can allow him all too long loan because this la only got title or by got some restriction is stop. I'm questionable me also. But otherwise, I stand here to be corrected. It will be the whole country, not only talking for Kokopo, but as an experience, an example. I'm raising this because it's happening here in East New Britain. Thank you. Before you may go to lunch, Chairman.
Now, you may want to thank for the contributors this morning, Deputy Governor, one-time Council, Alliance Officer, and our BSU Branch Manager. Thank you so much. Your insight is very important. I don't know how much to thank you, because it's great talking about these things and trying to find a solution. But if we don't get the buy-in of the most important part of this country, backbone, that is the financial sector, then it's going to be an effort to waste and time not well used. So we're really greatly grateful for your contribution to this country. And this is our country. It's our country. We will all finish here, and our descendants will continue. And we want to live a prosperous Papua New Guinea. Create it. It is your part of our architecture of the future. And so these contributions this morning are most invaluable, and really grateful for each of your time. Please don't go away. So if need arises, we should recall yourselves to some of the questions for the engagement might arise, and we can, while you're in the room, we can answer those questions. Thank you so much. So we go break quickly. Na coffee, sandwich stop, na refresh. You come back in 40 minutes.
Thank you.
When we come